Hi, I'm State Planning Attorney Gerald Eidelman, and today we're going to be looking at Knives Out, a film starring Daniel Craig and Ana de Armas. This movie has a will at its core, and we'll be looking at how accurate it depicts state planning. For those of you out there that haven't seen this movie, I'm going to set up the plot in order for you to understand the state planning issues at play. There will be a slight spoilers for the Knives Out, but I will leave several twists and turns unspoiled. This movie revolves around a wealthy mystery author, Harlan Thrombey, and his very spoiled heirs played by Jamie Lee Curtis, Don Johnson, Chris Evans, and Toni Collette. The film opens with a housekeeper finding Harlan dead of apparent suicide. As the police question the Thrombey family to get a better idea of what happened the night of Harlan's death, we get a reveal that Harlan's nurse, Martha, made a mistake in his medications and delivered Harlan a lethal dose of morphine. In order to cover up for Martha and her undocumented immigrant mother, Harlan directed Martha to take several actions to disguise her involvement before taking his own life. Now we got the basic plot set up. Let's turn to about an hour into the movie where the family is gathering for the will reading.
I've never been to a will reading.
You think it'd be like a game show, but think of a community theater production of a tax return.
Well, this is very interesting. It talks about it being a theater production, and that's exactly what this is. In all of my years of practicing law, 20-some years, I have never seen a will reading, especially with all of the family at the same place.
You know what, Richard? You want to go? You bet, Skippy. Let's go. You want to go? Come on. Hey, no, watch out now. Stop! Come on, I've been waiting for that.
So this is exactly why we don't want to read a will with all the family in the same room. The fact is that families who get along together during their lifetimes of the parents many times turn on each other when it comes times to receive their inheritance. Clearly, given the dynamics of this family, the dysfunction of this family, it would be a perfect reason not to put them all together and talk to them individually. Definitely, you would not have things such as reveals that they got cut out of the will and all those things until the will was actually read. So it's a little over the top. It's good for drama, but it's not good in real life.
Well, thank you all for getting together like this. It isn't legally necessary, but I thought because you're all in town and some of you are leaving soon.
Excuse me.
Well, that's very interesting that the lawyer starts with the fact that the will reading is not legally necessary. And that's the fact. Reading the will out to the family, gathering the family to read to them what they are entitled to receive from their parents or grandparents is not an unusual act.
Harlan altered his will a week before he died. He sealed it. He asked me not to submit it to the courts for probate until after his death. So, if anyone is confused about anything, we're all together. We can talk.
The lawyer is talking about that his client, Harlan, did not have him submit the will to the courts. Now, this is very crucial because depending on what state you are, wills needs to be filed with a court unless they're a dying will or a holographic will. That's one handwritten will. If it's not submitted to the court, many times even sealed, so the court doesn't even know it until it's time to open the will after the deceased is passed, the fact is that it wouldn't be valid. It would be considered an invalid will, and it would have no force of law, and whatever prior will was in place would be the one that would be effective.
Although I don't imagine any of it is going to be that complicated. Harlan's assets included
The house.
the house, which he owned outright.
60 million.
Yes, 60 million in various cash accounts and investments. And of course, the real asset, sole ownership of Blood Like Wine, his publishing company. Wow. Well, yeah, not too complex at all.
Now, you just got a glimpse of the will. And one of the things you notice right away is there are no signatures in the will. Not only are there no signatures, there's no notarization, there's no witnessing of the will. For a will to be valid in most states, it requires that it be witnessed by 2 or more witnesses, that they see and watch the testator or the person who's making the will sign the document and witness the fact that the person is a sound mind and is not being coerced into signing this will. You also need to have a document notarized to show that the person that signed was actually the person that was the testator, not some other person. So without all of those formalities in the will, this is just basically a piece of paper that has no force of law. Also of interest to note is that this appears to be the family attorney, the person who would have done all the documents for Harlan. In this case, we see that he didn't even know what the content of the will was. And so it makes you wonder whether some other attorney drafted it and he just received it, or this is something that was written just by the client, which is what it looks like, and submitted to the lawyer without any other will formalities.
This will be quick. I, Harlan Thrombey, being of sound mind and body and yada, 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 I hereby direct that all my assets, both liquid and otherwise, I leave in their entirety to Marta Cabrera. My entire ownership of Blood Like Wine Publishing, I leave in its entirety to Marta Cabrera. The copyright of its catalog, likewise, I leave in its entirety to Marta Cabrera.
No. That's not. No. That can't be.
No.
Can I see that, please, Alan?
That's right.
So this is why you wouldn't do it with everybody at once. What a surprise. We knew that the will was going to be something that was not going to be good if it was done last minute. It never is. It rarely is. Somebody was going to get a surprise. So here, the whole family got a surprise. And you see them in their mannerisms and everything. They're already up in arms. They're standing up. They're trying to complain. And you, as the lawyer, have no responsibility or ability to give them any explanation. This is what the client wanted, and this is what you're stuck with. So this is another reason why a lawyer would not want to be surrounded by the family when they read the new will.
Out! We are the Thrombies, god. This is still our house.
Oh, sorry. Likewise, the house at 2 Dearborn Drive and all belongings therein I leave to Marta Cabrera.
So this is an interesting development. Now, one of the first things you see is the attorney doesn't know everything that's in the will, even though he's got it in front of him. He didn't bother to read the whole thing. It took his assistant to point out to him that the house, oh boy, was also going to Marta. Now, what people don't understand is that there's 2 ways of passing assets to your heirs. One of those is to do this, have a will, and transfer those assets through a will. Now, the problem with a will is that, unlike in the movie, it doesn't automatically transfer any assets to the beneficiary until there is a court process called probate, in which we get to determine whether the will is valid, whether the heir is entitled to receive the assets, whether other people don't have claims against the state. I mean, clearly, if this has been probated, you can see clearly that everybody in the family would have raised some objection to the will, would have countersued in the probate proceedings to get some of the money from the will. Now, you're thinking probably the will says what it says. What is there to discuss? Well, there's many real different things that can happen and many different claims that can take place that may not be contemplated in the will. And this happens many times with very large fortunes. It happens with many celebrities, Michael Jackson, to name a few. What you notice is, in those cases, the probate proceeding can last for years. For example, the estate of John Denver, if you remember him, a country singer, actor, was tied up in court for 10 years because nobody could agree on what they were entitled to. And if I recall correctly, the estate of John Denver was about $20 million when it started. It was a few $100,000 when it finally got distributed because it spent 10 years litigating and paying legal fees to all the lawyers that got involved. This would be a classic case of where this would happen. Now, typically, when you have this much money, and it doesn't require, it's not about money really, but when you have these many assets, you're talking about very complex assets, talking about a publishing company, $60 million. Most people would not pass this through a will. It would be a disaster, as you can see. Typically, this is done through a trust where all the trust provisions are kept private and secret from the rest of the world. Now, you will later see that because this is a will, it was announced to the public, and Marta gets harassed, gets letters from lawyers, CPAs, everybody who wants to represent her, because now they know what's in the will, and it's a matter of public knowledge. With a trust, that doesn't happen. A trust is private. The matter is resolved behind closed doors, and it doesn't allow the rest of the public to take advantage of any of the heirs should they inherit a large portion of money. And it's also much more efficient and quick as far as the distribution. So if we had a trust here in place of this will, nobody would have known. Marta wouldn't have been bothered. It would have been all private. And they could have distributed the money directly to Marta right then, right away, without any proceedings in the court. And it would have saved a lot of grief, a lot of time, maybe not to the members of the family, but certainly to Marta.
Alan, there have got to be options here.
No. I don't know how many times I can repeat the same two pieces of information. If Harlan was of sound mind when he made the changes, and we all confirmed that he was...
Would a sound mind do this? How?
The very action speaks to unsoundness.
Not legally, no. You not liking what he did does not speak to testamentary capacity.
What about undue influence?
Yeah, undue influence. How about that? Huh?
Did you just Google that?
So this is a great example of what happens when everybody gets this inherited or somebody gets more than the other person do. The accusations come flying. I mean, I've had many occasions where one child gets disinherited or gets a lot less than the other child. And there's always playing the blame game. The question becomes, okay, what did you do to mother? What did you do to father? How did you convince them to give you more? And accusations fly back and forth as you're trying to find out why there's a difference in distribution between different heirs.
What about the Slayer rule? I did just Google that.
The Slayer rule obviously doesn't apply here.
Well, what the hell's the Slayer rule?
Well, it's if someone is convicted of killing the person, they don't get their inheritance.
Not even convicted, even if they're held responsible for their death in civil court.
Like OJ.
Yes, like OJ. But Harlan committed suicide.
Detective Blank, you said the investigation is ongoing. You made a point of that. Do you suspect foul play?
Mr. Blanc, if you please. There is much that remains unclear, but yes, I suspect foul play.
The Slayer rule has been around for many decades. This has been in the books in every state for many, many, many years. A great example, if you would, although it's an old case, but it's been brought back into the fore the last couple of years, the Menendez brothers. There were a couple of brothers, they murdered their parents, and they stood to inherit the parents' fortunes. Without the Slayer rule, they would have gotten the parents' fortunes, even though they were the ones that caused the crime that led to them receiving the fortune in the first place. Now that's interesting to mention, even if they're held responsible in civil court. So perhaps there's a crime, but there's no irrefutable evidence so that you can absolutely get a criminal conviction. Then, just like in the OJ case, they can turn to a civil court. And the standard for civil liability is much lower than for criminal liability. And if that person is found out to be civilly liable for the death of the testator, then they would not be entitled to receive anything from that person that they killed.
How'd you know this was the morphine?
I just knew.
You knew because there is the slightest, almost imperceptible differences of tincture and viscosity between the two liquids. You gave him the correct medication because you are a good nurse.
In fact, if Harlan had listened to you and called the ambulance,
he would be alive today.
Now, it's interesting that after the whole movie that plays out what seems to be Marta's murder of Harlan, that something else comes up, that somebody else might be involved in this, that somebody else may be looking for a way to apply the Slayer rule on purpose. And without spoiling the end, let me just say that there's many times when there's enough greed in a family that people tend to do things, not necessarily murder like in this case, but horrible things to other people. They litigate things to death. They try to disinherit others in the family. I have personally been a witness of that. I have personally had to defend people from such situations. This is something that happens not infrequently. And so it's important to note that it's not always the obvious that gives you the answer. There may be some things behind it. There may be some reasons why a parent disinherited a child. There may be some long repressed anger. So if you wind up with a less inheritance than you expected, it may not have anything to do with your parents or your grandparents loving you any less. That's one of the things that I usually do when people are making uneven distributions. Many times, like I had a client that divided, instead of doing 30-30-33 between all three of their children, they gave only one of them 10 and they divided the other 90% between the other two. Why? Well, the other two children had left the home when they were 18, 19 years old, made their own lives, and took care of themselves. The other child lived with the parents and off the parents till he was 45. So the parents loved him very much, but they considered they had put more than enough money during his lifetime so that they were not responsible, and the other children who didn't get the benefit of a lifetime support should get it after they pass. Well, this is Hollywood. This is a portrayal that makes for dramatic effect, but certainly it wouldn't happen like this. Marta wouldn't get the house just because they read the will. Again, there would be a process of probate or court process that would last probably a year, and in this case, I would argue years before she would ever have ownership of the house. The house might sit there empty and alone without anybody being able to use it for years. So while we like Hollywood endings, we like the drama, this is not real life. In terms of a rating on the movie, I give it 2 knives out of 5 for veracity regarding what happens when a person dies and the state disperses its assets. But let us know what you think. Have you run into issues with inheritances? Or do you worry about your own estate plan? Comment below and let us know your thoughts. And be sure to subscribe for more content like this. That's all we have today. I'm Gerald Eidelman with retirementhelp.com. Thanks for watching.